All right. Okay, moving on to our next question. It must be from Anonymous because we don't have a writer. So we'll just say Anonymous asks, do banks require that a co-signer be part owner of the second property as well? Would forming an LLC with the other individual help from becoming a co-signer? And that's the entirety of the question.
And that's why there's no writer on that. But I think I know what they're asking on that one. Okay. First of all, in general, banks love co-signers, right? If you co-sign on a mortgage or any type of loan agreement, you don't have to have a real interest in the property.
Okay.
But when it comes to real estate, most banks want the parties who are on the loan agreement to have a vested interest in the property. I actually know that question. That's why I could jump right into the answer. Okay. These people actually are really not, they call themselves co-signers, but really what they were guarantors, okay? And you know the difference between a guarantor and a co-signer?
No.
Well, not much. There's not much of a difference. A co-signer usually is somebody on a loan agreement, though, who's actually on a loan application. So you and I could go to the bank and we could borrow money, and we would be co-borrowers and we'd be co-signers, okay? Now let's pretend you go to the bank and you get your own loan, but the bank says, you know, we really like you, Blair, and we know that you're very active in the real estate market. We trust you. We just need a little bit more security. And do you have a friend or somebody who, is credible, like David Sobel, who would maybe co-sign or be a guarantor for you? So a guarantor does not have to have an interest in the property.
Okay.
Got that? So lawyers call, well, I don't know if all lawyers use this terminology, but the people who taught me, my mentors, basically said to me one day, you know what a guarantor is, David, don't you? And I said, I don't know. They sign on behalf of somebody else. And they're like, no, a guarantor is an idiot with a pen.
Yep.
Yeah, being a guarantor is not a great situation. You have to have a lot of faith in your borrower. However, I know we're going to go down a quick slippery slope. You can curtail the obligations that you may have as a guarantor. And there's a number of different ways to do that. Too long for us for discussion tonight. And you're probably sighing there, Blair, like, oh, good. But if you can go to our website at provenresource.com. We have a whole article on how to change, reduce, modify, limit your legal exposure and financial exposure as a guarantor. Okay?
Okay.
But a co-signer and a guarantor are very similar.
Okay.
Got that?
So to answer this person's question, the second portion of their question is, would forming an LLC with the other individual help from becoming a co-signer?
No, I didn't understand that part, but they're just trying to not hide, but put an extra layer between their personal liability to a bank and, their corporate liability.
Okay. Yeah, so it seems like this question is, there is someone who wants to help out, but wants to keep it kind of at arm's length a little bit, responsibility, liability, etc., which I don't blame them. So the last time I had a co-signer was student loans, like my parents co-signed student loans, but outside of that, I've never had a co-signer, especially for any real estate purchase. So that's not anything that I'm aware of anyway.
Here's the thing about the co-signer. So like when your parents co-sign for you, this goes to the illustration of, they're really co-applicants. Somebody looked at their financial and credibility and their financial wherewithal when they made the loan to you, Blair, let's say for your student loan. They still look to your folks. So the co-signer is somebody, from my perspective, is somebody who still they may not have to make a complete application, but they do have to be verified in their borrowing ability. You know, are they going to be a good debtor? That's what a co-signer is. And the guarantor is just one more person removed. We don't care who the guarantor is. If they, you know, most banks would just say, oh, you can guarantee if you have a house, maybe some money, but we're not going to really qualify you. If you want to stand up and step into the shoes of the borrower, go right ahead. That's the difference.
Okay. All right.
I do have one more comment though. If a loan is taken out by a limited liability company or an S corporation, pardon me, a C corporation, sorry about that. The corporation is the primary borrower. Then what a bank will do, however, is then make the individual a guarantor.
Okay.
The individual who actually has an interest in the company.
That makes sense.
Okay.
Okay.